Hello everyone, welcome to SG Learners channel. In this video, we are going to understand the concept of admissions under the Indian Evidence Act, covered from section 17 to 23rd. This is a very important topic for both civil and criminal cases. Section 7 defines an admission as a statement, oral or documentary, which suggests an inference about any fact in issue or relevant fact. In simple words, when a person makes a statement that goes against his own interest, the statement becomes relevant as an admission. The law treats admissions as important evidence because normally a person does not make statements against his own interest unless they are true. Therefore, admissions are considered strong piece of evidence. For example, if A admits that he borrowed 1 lakh from B, that statement becomes relevant against A. It supports B's case. However, admissions are not automatically conclusive proof. They are relevant, but they can still be explained or challenged. Now let us understand the essential elements of admission and what conditions must exist for a statement to be treated as an admission. First, the statement must suggest an inference about a fact in issue or relevant fact. In simple words, it must relate to the matter being decided by the court. If the statement has no connection with the case, it cannot be treated as an admission. Second thing, the statement must be made by a party to the proceeding or by someone legally connected to the party, such as an agent or representative. Random third party statements are not admissions. The third one, an admission may be express or implied. It does not always have to be spoken clearly. It can be written in a document, stated orally, or even inferred from conduct. For example, if a person signs a document acknowledging that he owes money, that signature itself becomes an admission. Similarly, if a person accepts goods without objection, his conduct may imply admission of delivery. So remember, it must relate to the issue, it must come from a proper person, and it may be oral, written, or by conduct. Now let us understand an important question. Who can legally make an admission? Under the Evidence Act, admissions are not limited only to the parties directly involved in the case. The law recognizes that certain persons connected with the parties can also make admissions that bind to them. First one, a party to the proceeding can always make an admission. For example, a plaintiff or defendant in a civil suit or an accused in a criminal case. Second, admissions can be made by an agent authorized by the party. If an agent makes a statement within the scope of his authority, the statement becomes admissible against the principal. Third one, admissions may also be made by persons from whom the parties derive their interest. For example, if someone purchases property from another person, admissions made by the previous owner may become relevant. In certain cases, partners in a firm may bind the firm through admissions made in the course of business. Similarly, statements made by co-parties may also become relevant under specific conditions. For example, if a partner in a business admits liability in relation to the contract entered into on behalf of the firm, that admission may bind the entire firm. So remember clearly, admissions may be made by party, authorized agent, person connected in legal interest, partners in business, within authority. Understanding who can make admissions is very important. Now let us understand the different types of admissions. Admissions are mainly divided into judicial admissions and extrajudicial admissions. First one, judicial admissions are those made during court proceedings. These include admissions made in pleadings, written statements, affidavits, or statements recorded by the court. Judicial admissions are very strong because they are made formally before the court. Generally, judicial admissions are binding on the party unless the court permits them to be withdrawn or explained. For example, if a defendant admits in his own written statement that he signed a contract, that admission becomes binding. The second one, extrajudicial admissions. These are those made outside court proceedings. They may be made to friends, relatives, police officers, or any other persons. These admissions are relevant, but they must be proved like any other fact. For example, if a person tells his friend that, yes, I borrowed money from him, that is an extrajudicial admission. The friend must come to court and prove that statement. Admission may also be classified as as expressed or implied. Expression ad, express admissions are clearly stated. Implied admissions are inferred from the conduct. So remember, judicial admission made in court, strong and binding. Extrajudicial admission made outside the court needs a proof. Now let us understand how strong an admission is in the eyes of law. Admissions are relevant evidence, but they are not conclusive proof of the matter admitted. This means that even if a person makes an admission, the court is not bound to treat it as a final proof. The person who made the admission can still explain or prove that it was mistaken or incorrect. However, admissions are considered very strong evidence because they come from the party himself. Normally, a person does not make a statement against his own interest unless it is true. That is why courts give serious weight to the admissions. In some cases, admissions may operate as an estoppel. Estoppel means that a person cannot later deny what he has earlier admitted, especially if another person has relied upon the admission. For example, if a defendant admits that he signed a contract, that admission becomes a strong evidence against him, but he may still try to prove that the contract was signed under mistake or fraud. So remember clearly, admissions are relevant and strong evidence, but they are not automatically final or conclusive. The court will examine the circumstances in which the admission was made before relying upon it. Now let us understand an important limitation. Not all admissions are admissible in the court. Certain admissions are excluded because of public policy of unfairness. One important example is statements made during compromise or settlement negotiations. These are often made without prejudice. Such statements are protected and cannot be used as admissions in the court. The reason behind this rule is simple. Law encourages parties to settle the dispute peacefully. If every settlement discussion could be used against a party later, people would hesitate to negotiate honestly. Another important limitation is when admissions are obtained under inducement, threat, or promise, especially in criminal cases. If a statement is obtained by pressure or coercion, it may not be admissible. For example, if during a settlement discussion a party offers to pay some amount just to close the dispute, that offer cannot be treated as an admission of liability in the court. Similarly, if a statement is made under the threat or force, the court may reject it. So remember, admissions are powerful in evidence, but fairness and public policy place important limits on their use. To summarize, in this video, we clearly understood the concept of admissions under section 17 to 23 of Indian Evidence Act, including their meaning, types, evidentiary value, and limitations. In the next video, we will move to another important topic, that is confessions under the Evidence Act, and understand how they differ from admissions. Thank you for watching and keep learning with SJ LearnX.